Well, hey there, folks. This is Bill O'Leary here, and I'm going to record this video to talk about the topic of how do you create an estate plan for a blended family. So, in this video, you're going to learn basically three things. One, what is a blended family? I'll define it for you. Two, why the estate planning for a blended family requires more thought and care to be true. And three, some planning solutions for a blended family. So again, my name is Bill O'Leary. I'm an attorney with my firm Legacy Planning Law Group in Jacksonville, Florida, and we focus just on estate planning, elder law, and probate and trust administration. So let's go ahead and get into it. A blended family. This is where people have remarried and have children from previous marriages or relationships. And preparing an estate plan for a blended family for sure really calls upon unique challenges. Lots of people that are entering into a blended family, they already have a will or an estate plan, let's say that was done sometime during the previous marriage. The problem is they forget to update it, or they don't even realize the importance of having to update it. Some people assume that, hey, if they just leave everything to their new spouse when they die, that person, they'll just automatically pass everything down to the children from each marriage in a fair and equitable manner. And then there are those other people that never bother to create an estate plan or a will of any kind. And I can tell you that result is almost certain to be a disaster. Spouses in a second marriage need to have a frank and honest conversation for how their respective children from their previous marriage will be accounted for. And when doing estate planning for mixed families, parents have to exercise extreme caution when separating assets and finances. And as I said, boy, it's tempting to just do the simple thing, leave everything to your new spouse. But again, when there are children from a prior marriage, that really can cause a problem. Blended families, just as an example, they may want to set up a trust to guarantee that each set of children will get, the inheritance that is intended for them when the first spouse dies. And this basically will prevent one set of children from getting disinherited, will prevent the surviving spouse maybe being influenced by his or her children from cutting out the first deceased spouse's children. Let's look at a particular case. It's the case of Matt and Jenna. They're two divorcees who got married again to each other, and they each have children from a prior marriage. And by the way, they have one child together, a teenager. Each of them has a simple will in place that they did when they were married to their first spouse. Each of them, they want to make sure that the other spouse, as well as their child together, they're going to be taken care of when the first spouse dies, but also want to make sure that there is something set aside for their children from their prior marriage if they're the first to pass. So, do you think a simple will that was done a long time ago will do that? Is that enough? The answer is no, absolutely not. If they have everything go to the surviving spouse, which is how most folks have things set up, it's just not going to cut it. This places a whole lot of confidence and trust in the surviving spouse not to change up the plan. So let me ask you this: what's to stop the surviving spouse from, let's say, changing his or her will after the first spouse passes away, cutting out the first spouse's kids from the overall plan? Think it can't happen? Think again. Not only can it happen, but it happens, and happens fairly often and quite easily. So as soon as Matt and Jenna are married, what they should have done is said, oh, this is a major life event. This is an indication that we need to go ahead and change up and update our estate plan. When they got married, their will should have been updated big time. The solution, frankly, is instead of putting together that simple will that they each did long ago, is put together and put in place a trust. A trust, you see, can provide, in effect, think of them as guardrails, okay, guardrails to make sure each set of children, let's say Matt from his first set and Jenna from her first set, from her first marriage, each set of children, that they are going to get at least a share of the overall collective estate. So it provides concrete assurance, I guess you could say, that the kids won't get cut out. In addition to having a trust in place, there's some other things that could be done to provide for the first set of kids. Let's say maybe naming them on, let's say, a life insurance policy, or let's say a retirement account. It frankly requires an all-in approach, and a good estate attorney can help. Then there's the issue of naming the executor or the personal representative. In the case of a trust, that decision maker is what we call the trustee. Or maybe how about naming an agent under a financial power of attorney or a healthcare surrogate designation? Blended families need to be careful and very intentional in making these choices. Married couples in a first marriage, let's say, usually name the other spouse as the initial decision maker, but in blended families, you may choose different people for different purposes. So, as with so many issues in a blended family, the potential, frankly, for conflict is enormous. And as with so many issues in a blended family, the potential for getting it right is there if you just seize the moment. Again, this is where the help of a good estate attorney is invaluable. Sometimes the best person to handle the financial affairs in a blended family situation might be a detached third party, a professional fiduciary. They are licensed professionals who can be hired to make financial decisions should you become incapacitated or pass away. They go through background checks, and you can even interview them to make sure that you're comfortable knowing who's going to be handling the affairs. This is a great way for a blended family to avoid conflict. And again, your estate attorney can help you arrange this. One final word about stepchildren. Many blended families obviously have stepchildren. Do you think stepchildren have inheritance rights? No, unless they are formally adopted, and they're typically not. Stepchildren have no inheritance rights. So you have to, if you want to provide for a stepchild, you have to specifically identify your stepchild as a beneficiary in at least one of the estate planning documents, like your will or your trust, or let's say a beneficiary designation. You have to do that if you want them to inherit. So if you'd like to know a little bit more about estate planning for a blended family and maybe how we can help, we'd love to talk to you. So we invite you to take that easy first step. Just schedule a free 15-minute discovery phone call. Again, no charge. Scheduling is easy. Just click on the link below this video, take you right to our booking calendar, and we'll jump on the call with you. If you've enjoyed this video, we'd ask that you like it, and better yet, share it with your friends. And do subscribe to our YouTube channel. Bill O'Leary, signing off for now. Go make it a great day and a better world.